Hello, government students. Today we're going to be doing notes 4.1, the federal court system. Your essential question: what is the judicial branch and what powers do they have? So, today we're going to be talking about the national judiciary. Article 3 of the Constitution established our judicial branch. So, as we've been going through the Constitution, remember Article 1 established our legislative branch, Congress. Article 2 established our executive branch, the presidency. And Article 3 has established the judicial branch. So, there are two court systems in the United States: the national judiciary that spans the entire country, and then we also have courts that are ruled by each of the 50 states. The Constitution created the Supreme Court, which is the highest court in the United States, and left Congress to establish the inferior courts, which are the lower federal courts. There are two types of federal courts: there's constitutional courts, and then there's special courts. As you can see here, we have the constitutional courts over here on the left side, and these special courts are different kinds of courts for specific reasons. So we have like a tax court. So anything that has tax purposes would go through the tax court, or anything for Veterans Affairs would go to the Court of Appeals for veterans claims. We have territorial courts, so courts for those specific things, but they can all go up to the Supreme Court. Jurisdiction is defined as the authority of a court to hear a case. So, to hear a case means to try a case and to decide. So, to have a trial and have a decision at the end of that case. So, the Constitution says the federal courts can hear a case either because of the subject matter of that case or because of the people involved in the case. There's different types of jurisdiction. We have exclusive and concurrent jurisdiction. So, exclusive means that cases can only be heard in federal courts. Okay, so exclusive, kind of like one thing, can only be heard in federal courts. Many cases may be tried in a federal court or a state court. If they can be tried in either a federal court or a state court, then they would have concurrent jurisdiction. So, concurrent meaning more than one. So, we have concurrent jurisdiction if they can be tried in either one. A court which the case originally is heard, so it's first heard for the first time, is said to have original jurisdiction over the case. A court that hears a case on appeal, so if someone doesn't like the outcome of that case, they can appeal the case and it can be brought to a higher court. So the court that hears the case on appeal from a lower court has appellate jurisdiction over that case. The Supreme Court can do both. So the Supreme Court can hear a trial for the very first time and have original jurisdiction, or they can hear someone's appeal, so the appellate jurisdiction. They have both of those. So the power to appoint judges to the federal courts falls on the president. That's one of those executive powers, is to appoint someone to go into those positions. The president nominates whoever they want for Supreme Court vacancies. So if someone is no longer on the Supreme Court, the president gets to nominate that person to fill that position. And then it has to be approved by the Senate. So the president makes their nomination, goes to the Senate has a hearing, they investigate whether they believe that person deserves to be on the Supreme Court or not, and then the Senate has their vote. Sometimes these can be very contentious. In recent history, Clarence Thomas, when he was getting appointed to the Supreme Court in 1991, he was accused of sexual harassment by Anita Hill. So that was very controversial, and they ended up approving him anyway. And so he did get appointed to the Supreme Court. And then in more recent history, in 2018, Brett Kavanaugh here on the right side, he also was accused of sexual misconduct. He was actually accused of sexual assault by Dr. Blasey Ford over here on the left hand side. So she did accuse Justice Kavanaugh of sexual assault, and he denied it. It was very contentious. There was a lot of protests going on outside. Brett Kavanaugh was very upset. There was a lot of yelling. There was a lot of crying. It became a real spectacle. But he, again, was approved for the Supreme Court. So the term and pay of judges are appointed to the constitutional courts and they serve for life. So once we take a Supreme Court justice, they're chosen by the president, they're given to the Senate. The Senate makes the decision whether to approve them or not. Once they're on that Supreme Court, they can serve until they die. They can serve the rest of their life. They can also retire whenever they feel that they would like to, but they can serve for life. Judges of constitutional courts may only be removed by their own will, so if they die or if they choose to quit the job, or through impeachment. So, just like the president, they can be impeached. Only 13 federal judges have ever been impeached, and of those 13, 7 were convicted, so 7 were removed from office. Right, moving into the inferior courts. We have 94 federal judiciary districts. We have at least one district in each single state, one district in Washington, D.C., and one district in Puerto Rico. Of course, larger states, states like California, have bigger populations, are divided into more districts because they have more people. District courts have original jurisdiction. They can hear both criminal cases and civil cases. And we have the Court of Appeals. So obviously, they're only dealing with appeals, so they don't have original jurisdiction. So they're dealing with appellate jurisdiction. So they're hearing cases that are on appeal from a lower federal court. So if you have your court case in a lower federal court and then you want to appeal it, you don't like the outcome, then you would go to a court of appeals after that. So this graphic here shows you how federal cases can be appealed up to the Supreme Court. They can go through different court systems to make their way up to the Supreme Court. Or, like we said earlier, the Supreme Court also can have original jurisdiction, so they can take a case for the first time straight to the Supreme Court. We do have some other courts, like the Court of International Trade and the Court of the Federal Circuit. Just so you know, we do have them, but I'm not going to have you be tested on these or anything. All right, the Supreme Court. The Supreme Court has 9 members. They're called justices. The Supreme Court has something called judicial review. And this means that they have the power to determine the constitutionality of a governmental law or action. So, some would argue that the Supreme Court actually is the strongest branch of the 3 branches because while Congress can make a law, they can send it to the president can sign a law, sign a bill into law. The Supreme Court can actually rule a law after it's already been established unconstitutional. So, they can cancel out any law that they don't believe is constitutional. The Supreme Court first asserted its power of judicial review in the case Marbury v. Madison way back in 1803. So the Supreme Court has both original jurisdiction over cases involving 2 or more states. So if any case has 2 or more states that are having some sort of issue, it automatically starts in the Supreme Court. And most court cases that are heard by the court are appeals. So most cases that go up to the Supreme Court have been tried in a lower court before and they're being appealed up to the Supreme Court. In order for a case to be heard by the Supreme Court, 4 of the 9 judges must agree that it should be placed on the court's docket. So, of course, we have probably millions of suits that happen every single year, criminal investigations, we have civil lawsuits, we have all sorts of trials that happen every single year, and the Supreme Court can't hear them all. A lot of people want to appeal all the way up to the Supreme Court, want to change laws, but the Supreme Court can only hear so many cases per year. So they get to decide which cases they're going to hear. So as long as 4 out of the 9 judges agree, then it gets placed on the court's docket. So the Supreme Court works kind of like other courts do. They listen to oral arguments. So when the Supreme Court accepts a case, it sets a date for which both lawyers will present their oral arguments. So just like you've seen on TV with different courtroom dramas, how both lawyers then present why they think they are right. They have to have briefs, which are written documents that are filed with the court before their oral arguments begin. And they have the court in conference. So the Chief Justice, which is the person who's in charge of the Supreme Court, they preside over a closed door conference in which the justices will then present their views, whether they believe this side or that side is correct on the case at hand. Once a court finishes its conference, it reaches a decision, and the opinion of the court is written. So the majority opinion is the formal opinion that's announced by the court. So because they have 9 members, they have to have 5 to be a majority, and that would be the decision that's made. So the majority opinion is released by the court. Justices can also release concurring opinions. So sometimes they're able to release information and they're saying, hey, I concur with this majority opinion because such and such and such. A lot of times, the majority opinions will set precedents, so examples for similar cases to follow as we go on. And they also have the ability to present a dissenting opinion. So if the court makes a decision and any of the justices don't like that decision that was made, they can release a written statement as well called a dissent. These are dissenting opinions saying why they dissent, why they disagree with the court's majority opinion. Our late Ruth Bader Ginsburg was known for dissenting. She was frequently someone who started to dissent later on in life on her during her time in the Supreme Court. This is the Roberts Court. So, how we name Supreme Courts that are sitting are by whoever the Chief Justice is. So, the Chief Justice is sitting here in the middle. His name is John Roberts. He is the head of the Supreme Court, so he's the one in charge of this group here. And so, we call the court the Roberts Court. Now, this isn't an actual current picture because we have lost Ruth Bader Ginsburg. Justice Ginsburg did pass away this last fall, so I don't have an updated picture for you of our new Supreme Court because, again, we are in COVID times, so they don't have a group picture. But Justice Amy Coney Barrett replaced Justice Ruth Bader Ginsburg after her death in the fall of 2019. So, right before the election, President Trump was able to nominate a new Supreme Court justice. And because there was a Republican majority in the Senate, they were able to get her approved, and she now sits on the Supreme Court. And this is the breakdown of the court right now. So just wanted you to be able to see the Supreme Court in 2021. Of course, we have our Chief Justice, John Roberts, and now we have a majority conservative. So we have 6 conservative justices and we have 3 liberal justices. So this is the current makeup of our Supreme Court. So when cases reach the Supreme Court, these are kind of their political leanings, more conservative court than a liberal court. And this is directly influenced by whoever the president is. So as you can see, I put all the ages here so you could see their ages right next to their names as well. So our oldest member of the Supreme Court is Justice Stephen Breyer. He is 82 years old. So, may she rest. Ruth Bader Ginsburg, she was in her 80s and she just passed away. And she was liberal, but she was replaced by a conservative president because that was who happened to be in office at the time. So we got to make sure we look at our Supreme Court as well when we're making our decisions about who we elect to be president. If we want the Supreme Court to be more conservative, we should choose more conservative candidates for president. Or if we want our Supreme Court to be more liberal, we should choose more liberal candidates to be president. And that's the end of your notes for today. So go ahead and write a summary, a couple sentences about what you learned.